Victory in New Jersey. Let's go ahead and talk about it. What's up, Wolverines? Welcome back to John Crump News. Today we're going to be talking about New Jersey and what is going on there. If you don't know, New Jersey, after the Bruen decision, passed these really unconstitutional gun laws similar to the New York's Concealed Carry Improvement Act. FBC sued in the Garden State and took the state to court, saying that the state was violating the Second Amendment by not only the sensitive places, but some of the licensing scheme requirements. And they won a TRO, which is a temporary restraining order. Now the judge has came back and issued a preliminary injunction against New Jersey from enforcing most of its sensitive areas. The part about the licensing scheme, the judge did say that that is constitutional. I have a disagreement with that, but hey, what can you do? But the sensitive area portion of the law has been enjoined, which means it cannot be put into effect. New Jersey did not show that there is enough historical analogs in the judge's opinion to say that these sensitive areas are constitutional, and they can't show that because there aren't any historical analogs. Remember, for any type of gun law to be constitutional, the state has to show that it is consistent with the original text, history, and tradition of the Second Amendment, basically from 1791. They have to look back at 1791, see what laws were in effect there, and compare the modern laws to that. The ends means test, which was what they used to use, which means it was interest balancing. The interest of the state versus the interest of the people is gone. As Clarence Thomas put it, the Second Amendment is not a second-class right, and that's what they treated it as for a long time. Now let's talk about New Jersey's response to this. New Jersey Attorney General Matthew Platkin, whose name the case is in, it's Coons versus Platkin, said today's decision is devastating for public safety. Over and over, the evidence has shown that keeping firearms out of sensitive places will keep our residents safe, and our elected officials pass sensible laws to do exactly that. But the court now insists that we are powerless to protect New Jersey residents and proclaims that the Second Amendment requires allowing guns at parks and beaches, in libraries, at public gatherings, in zoos, and even in bars, among other sensitive places. This decision is bad constitutional law and bad for New Jersey. We will be appealing immediately. Basically, what they're saying is that they are going to appeal to the circuit court and ask them to overturn the judge's decision. What they will probably also do is ask for an emergency stay on the preliminary injunction, which I'm not sure that they will get. The next step will be the appeal to the circuit court, where a 3-judge panel will hear the case. No matter who wins, each side will have an opportunity to ask for an en banc hearing, which means the full bench will hear it. So if you lose, you can ask for an en banc, or you can go directly to the Supreme Court. I think whoever loses at the 3-judge panel level will ask for an en banc. If they get denied, they can go to the Supreme Court. If they are granted, the full bench will hear the case. Now, when it goes to the Supreme Court, they have to file what's called a writ of certiorari and ask the Supreme Court to take the case. Basically, it is a petition to the Supreme Court asking them to hear the case. There is another case ahead of this, and that's the GOA case in New York, the CCIA case, which is basically arguing on the same principles. So we will have to see how that turns out, but this will have a lot of effects on a lot of other states, such as Maryland, that has very similar laws. When Bruen was first decided, after the first couple weeks, when things didn't really change, people were asking me, what is the big deal about Bruen? It's not making a difference. It's not making a difference. And I had to tell people that they had to be patient, that Bruen was a massive decision, probably the biggest case in Supreme Court history but it's going to take time. And now we are seeing the fruits of that come to fruition, whether it's the challenge to the CCIA in New York, the New Jersey thing, down in Virginia, the 18 to 20-year-old decision. It is working, and we are seeing a difference, and that is thanks to Clarence Thomas and his brilliantly written statement on Bruen. His opinion on Bruen was fantastic. All right, guys, I have a little virtual toy drive going on. My niece Bella died a couple years ago from DIPG, which is childhood brain cancer. It's a really aggressive form of cancer, really nasty stuff. May is Brain Tumor Awareness Month, so we are doing a virtual toy drive. I'm going to link that down below. It's also at crumpy.com/Bella, where you can buy a toy. Jessica D is the recipient, and it will be delivered to the Ronald McDonald House, which helped my niece out tremendously when she got sick. Her make-a-wish was to help other children. It wasn't to go to Disney World. It wasn't for this. It wasn't for that. It was to help other kids. So every May, we do this virtual toy drive, and we get as many toys as possible. There's also other stuff on there. But if you can help out, please go to crumpy.com/Bella. It's going to redirect you to an Amazon wish list. Buy anything on there, and it will make a difference in a sick kid's life. So that's it. All right, guys. If you like what I do here, like, comment, and subscribe. If you don't like what I do here, too bad. All right, guys. Stay ever vigilant, stay ever free, keeping the fight. I'm out of here, Wolverines, motherfucker.